All right, let's have a look at today's daily tips and updates. My name is Ian Dutton. I'm the editor of the South African Medico Legal Reports, 17th of March 2025. What we're going to have a look at today is assessing the issues to be decided. It's a bit of a general category, assessing the issues to be decided. It's the first thing that the expert should be doing when they settle down to assess a matter, usually preparatory to holding an assessment or start going through the file. What must be foremost in the expert's mind is which issues should be addressed. But the specific aspect of that which I want to deal with today, and then we've got a very recent case to demonstrate what goes wrong if this principle isn't applied. Okay, so when you're looking at the issues in dispute, at paragraph 3.6.9 of the expert witness guide, we deal with the following. It is extremely important that expert witnesses clearly and fully identify and set out the issues which will be addressed in their report. Two things: identify the issues, set those issues out in your report so everybody knows which issues you are applying your mind to. That's any other expert, your attorney, the judge, anybody that reads that report at any stage will know which issues you're dealing with. Then, let's get a little bit more specific. In most cases, the general nature of the issues in dispute are initially defined by the pleadings in the case. The pleadings in the case, experts should be familiar with what the pleadings are. That's the written case as set out by the attorneys or the legal representatives. More accurately, could be an advocate, could be an attorney that drafts the pleadings. Either the particulars of claim, which are attached to the summons, or the plea. You must be familiar with those terms and with those documents. There are exceptionally other types of pleadings as well, but that's beyond the scope of this presentation. With the issues being more clearly defined through interaction with other experts as the court process develops. So what happens is the pleadings initially identify those issues. But then those issues are more clearly defined. The same issues get a bit more color and shape and focus as the process develops. But very importantly, the issues are set out in the pleadings. Very important for experts to understand that the parties are bound by what's contained in the pleadings. Why is that so? Because of a very fundamental principle. You cannot ambush, you cannot have a trial by ambush. In other words, a party cannot be taken by surprise by having new evidence led at a later stage. That's what the pleadings are there for. The other point which is related to that, pleadings can be amended, but proper notice must be given. Now, what does that mean in practice? You should, when you receive your instructions from your expert, as an expert witness, receive various information from your instructing attorney. So, contents of instructions to expert witnesses. Again, the paragraph reference is to a paragraph in the expert witness guide. Well-drafted instructions to an expert witness should contain the following, and we go through in some detail what should be contained. But at point number 5, the particulars of claim and other pleadings. In other words, a copy of the relevant portions of the pleadings should be provided to the experts, as well as witness statements and expert reports that are relevant to the advice or report. So you should receive a fairly comprehensive instruction if there have been other experts that have looked at it. But importantly for today, included in your instructions should be a set of pleadings. Let's have a look at what happens when you don't get provided with a set of pleadings and where the experts are not aware of what's contained in those pleadings. In Vilakazi versus Road Accident Fund, Vaderman AJ held the following. To the extent that the experts who prepared medico-legal reports recorded different injuries from those listed above, and those were injuries which were set out in the particulars of claim in the summons, and those claimed in the plaintiff's particulars of claim, those injuries were not before court and could not be taken into consideration in arriving at a decision on the plaintiff's claim for future loss of income. In other words, what happened here is that the particulars of claim, the summons, set out certain injuries. Those injuries are then locked in unless the pleadings are amended. The expert witnesses assessed the plaintiff, found different injuries. The judgment is silent on exactly the nature of those injuries, but very importantly, look at the attitude of the court. If those injuries are not set out in the particulars of claim, the court simply has regard to the disregard of those injuries. Simply will not have any regard to the injuries. That is why we say it is extremely important that the experts be aware of what has been pleaded. If they find injuries that don't accord with the particulars of claim, they must bring that to the attention of the attorneys and let the attorneys then properly amend their pleading so that the injuries are before court. Incidentally, this doesn't only apply to injuries, although this example demonstrates the general principle very well. Any issues that are not contained in the pleadings will not be properly before court and may very well not be able to be raised by the court. Had the instructions to the experts have included a copy of the pleadings, this situation could have been avoided, as the experts would then have been able to alert the attorneys to the fact that they had identified different injuries to those set out in the plaintiff's particulars of claim. And I've referred to the expert witness guide. There's a copy of the expert witness guide. We will put up from time to time links on how you can purchase the expert witness guide. It's a very helpful booklet, and everything that, or most of the information that comes up in these tips and updates is contained in the expert witness guide, or at least the fundamental principles are, and we might expand a bit on those principles as we have done today. Thank you very much for your time.